All right, everyone. Good afternoon. Welcome, welcome, welcome. It's so good to see all of you. Thank you for tuning in for week 4 of LIBOR's Global Success Month. Today, we are talking about U.S. immigration and visas. One area that makes global real estate transactions more complicated than domestic ones pertains to your client's immigration and/or visa status. As you may or may not know, many U.S. real estate markets rely on these programs for economic growth and market development. Today, we have the honor of bringing back Steve Maggi, Esquire, founder of SMA Law Firm, a specialized U.S. immigration and consular law boutique firm. Throughout the webinar, if you have any questions, please put them in the chat or use the Q&A to be addressed later on. Now, to introduce a man who really needs no introductions. Steve Maggi was born in Argentina and raised in the U.S. He graduated from Stuyvesant High School in New York City and the University of North Carolina, where he studied broadcast journalism and history. He then received his JD at Georgetown University Law Center. Steve is a U.S. immigration and consular law attorney with almost 20 years of experience. His law firm's motto is building the bridge to your American dream, because his mission is to help foreign nationals achieve their unique version of the American dream. Steve launched SMA in 2004 and is considered an industry expert. He has been interviewed by ABC News, CNN, NBC, and Bloomberg, to name a few. Under his supervision, SMA provides comprehensive immigration and consular law services, including assisting U.S. businesses and their sponsorship of foreign nationals through employment and training visas and green cards, investment visas for startups and green card-based investments, as well as family-based petitions and humanitarian cases. With respect to SMA's consular practice, Steve has represented clients at over 50 U.S. embassies and consulates around the world in their visa and waiver application processes. Let's give a warm welcome to Steve Maggi.
Wow, thank you so much, Evan. You guys can hear me, I hope?
We can hear you.
Fantastic. Wow, what an honor. I looked back at the presentations I've done for LIBOR, and it's been 6 years now of collaboration, I think almost going on 7. I've met some incredible people in your organization over the years. This is my worldwide debut, not wearing a suit. I'm a little embarrassed, to be honest. My suitcase is somewhere in between the state of Ohio and New York. I'm in Michigan right now at the university where they let me use an office for this. So this will hopefully be the last time you see me like this, but I promise you I'm a professional attorney. Okay, well, anyway, I feel very comfortable talking to all of you. I have a long-standing relationship with a lot of you. And so what I wanted to do today was be ambitious. I know the title is about updates, and I will give some of those, but updates really to me means bringing you up to speed on what immigration law looks like today. And that's also part of giving you the building blocks. So what I'm going to do is share my screen here. Let me know if everything is okay with that. Hold on. And you should be able to see. Evan, is my screen up?
We are good.
Okay, so here we go. I'm going to get going here. Let's see, does it work when I move it? Perfect. Okay, so here's an overview. As you can see, I'm not going to read all of this, but there's a lot that I'm going to try to go through today. I'm happy to have LIBOR share this presentation with you if you make that request. Anybody's that couldn't attend, you know, you're welcome to have a copy of this as well. And I know that we're recording this, so this is the overview. We're going to go through a lot, and I want to give you just starting from the basics. And some of you have heard my presentations before and might have seen some of this, but let's just go through the basics first. This is really an important part to understand, that the U.S. immigration system is not basic. It's very complex, and there are different entities involved in this. And sometimes I have to represent my clients on 3 different levels. The first one is immigration services, where people submit petitions, for example, to sponsor their spouse or their family member, or an employer is sponsoring a foreign national for a specific job position. Something called a change of status, where you change from one temporary status to another, or an adjustment of status, which is where you go from a temporary status to permanent resident status, what we know as a green card status. That's immigration services. The next one is Customs and Border Protection. They're the people that you see on TV now because of the border crisis. There are specific checkpoints or entry points. They're called ports of entry, where people can apply to enter the US. That includes all the international airports within the United States, which is, more than 100. And then you have the US Department of State. Most US immigration attorneys do not have thorough experience when working with the embassies and consulates. And this is where two things happen. Number one, visas are issued or not issued. So there's an adjudication made there. There are interviews. The most common one obviously is tourist visas, but there are interviews that are done there to decide whether someone qualifies for a visa. The second thing is they do an analysis of their what's called admissibility to the US. Are they eligible to enter the US? Do they have prior immigration infractions or criminal convictions or any sort of record that would make them ineligible for the visa or inadmissible? And they also look at what's called intent. Does their intent that they're declaring correspond to the visa that they're applying for? Because what they're trying to avoid is giving people visas that they will then use to stay in the United States past the time that they're allowed, which is called an overstay, which has happened in millions of cases over the years. There's also this policy of checks and balances, but it's really complete chaos and stagnation, because you have the executive branch, which, if you've seen my presentations, and the last one we did, I think October 2021, was really concerned with what's happening with the borders, what's happening with COVID protections. There were several travel bans in place. There was something called the national interest exception that we had to deal with. And that all comes from executive powers. That all comes from what are called executive orders or executive memorandum, which allow the president to put law into effect without actually creating law, until it's then questions in the courts, and there's a legal decision made to stop those things from happening. And so during COVID, we've seen just a lot of back and forth of things being in place, not in place. They're constitutional, they're not constitutional. And that's where the judicial branch comes into play. And then we hear this all the time. If any of you are paying attention to what's happening with the immigration crisis, as we call it, it always comes back to the same concept, which is we need actual law. There has not been an immigration law passed since 1986, way before I started practicing law. Nothing has changed. And so without real legislative action, this mess that we're dealing with is going to continue. Okay, so let's talk about a basic concept. I've reviewed this in years past, but what is the difference between status and a visa? Status is what authorizes you to remain in the US. The visa itself is a physical stamp you have on your passport that you've received at a US embassy, which allows you to enter for a specific purpose. So if you're a tourist, you're allowed to enter for reasons of tourism or pleasure, but you cannot work. If it's a work visa, usually it's tied to a specific employer. You can't use that to then do other things. And so the status that comes with that visa is the one that you have in the United States. That is different than an immigrant visa. An immigrant visa is issued to somebody who will be living permanently in the United States. And that's when you get your green card. And this can be based on a family-based petition or an employment-based petition. And we'll talk about all those categories coming up. The one that's a non-immigrant one is temporary. So you see there, it says tourism, medical treatment, business, temporary work or study. Those are all temporary visas that have a specific end date. And those are simply permissions to enter the US. One of the most important things you can let your clients know, and this happened a lot during COVID, is to check what's called the I-94. I-94, they can type in I-94 in Google, and they'll come to the website of Customs and Border Protection, which allows them to pull up their record with their passport information. And that tells them, authorized until date. There's a specific date that they are authorized to stay in the US. They have to absolutely stay with that. And that doesn't correspond to their visa, because their visa might be 1 year, 3 years, 5 years, or even 10 years if it's a tourist visa, but their authorized stay might only be 3 months or 6 months. And so that's the guiding principle. If they pass that I-94 date, they're overstaying their status, and that can lead to their visa being canceled. Once you have a visa canceled, it's very difficult to get another one. Let's talk about the alphabet soup of visas. I just did a presentation on this, and I thought it would be good to incorporate this. People can get dizzy from this. There are literally visas for every letter from A to V. No W, X, Y, and Z, but that's a lot. That's 22 different categories. At the same time, there are 39 countries that don't require a visa to enter the US temporarily. That's called the Visa Waiver Program. So if you have clients from Chile, from almost every EU country, as well as Japan, for example, they can use that program. They have to apply every 2 years through a system called ESTA or ESTA. And that allows them to enter the US for two purposes: as a business visitor or as a tourist. A business visitor does not mean that they can work for a US company. That requires an employment-based visa. Those are very important things, but they're very useful for setting up companies or subsidiaries of existing companies that they can use as a bridge to apply for a work-based visa. To add to that, there are also permanent visas that start with either EB, which is employment-based, or F, which is family-based. And those are different categories, and we'll talk about those. So there are a lot of different things, and it's very important to not mix and match. I have a company that I work with that is always confusing the E2 and the EB2, completely different things, and it's very important to understand the basics so you don't confuse them. So this is a lot of information. So I'm gonna try to break this down into black and white, and then of course there's the law. It always has gray areas too, right? So the simplest way to break this down is time and intent. Temporary short-term visas can be used for 6 months at a time, like the B1, B2. But the intent always has to be to return to your home country. It's important to understand that when your clients are entering the US, they have to express their intent. What is the purpose of each visit? Every time you enter the US, you are what's called applying for admission. That means that just having a visa does not guarantee your entry, because if you say you are planning to study, but they find on your phone, which they can check in what's called secondary inspection, emails confirming that you're going to be working, even though you're not authorized to work, they can deny you entry to the US. They can even bar you. So it's really important that the intent always be to return to your home country if you're coming in on a short-term visa, especially as a tourist. It is possible with those visas to do a transition to another status, but you cannot do it as soon as you enter the US, because then they will infer that you had what's called previous intent, and they can deny your case. So this is the Customs and Border Protection aspect or arm of the immigration system that I talked about. And that's why we advise our clients at all phases of their immigration process. And sometimes we even consult with clients just before they enter the US, so they know what documentation to take and what to say. For people who are part of the Visa Waiver Program, the advantage is you don't have to apply for a visa, but the huge disadvantage is that you cannot change your status. So you don't have technically a visa status. You have it waived. It means all you can do is stay for up to 90 days, then you have to leave. During COVID, we had a lot of clients who entered as tourists, then they couldn't go back to their home country, and they extended or they changed to student status, or they invested in a business and got investment-based visas. That is possible when you enter with a visa, but not with the Visa Waiver Program. Let's talk about some temporary visas then. The ones that you'll see most of are F1 students, M1 is vocational students, and then you have J1s, which are used by a lot of companies, including my law firm. I've sponsored about 8 different foreign nationals to work with me. They're very useful if any of you work with employers that are looking for a trainee or an intern to have for 12 to 18 months. The J1 program is very useful. But here's the caveat. You have to make sure that they are not given a 2-year restriction, and that will be on their form as well as on their visa stamp. If it says not subject to 212E, that means they are able to then bridge to a different visa status or eventually come in before 2 years is up. Otherwise, they are stuck outside the US for 2 years, and sometimes it's not worth that downside, okay? F1 students are the ones, if they're in university programs, a lot of them are eligible for work authorization. It's called optional practical training, or OPT. And they can use that period to then be sponsored for other visas. The main one that we'll talk about is called H-1B. Let's talk about a few other employment-based temporary visas. The important thing to keep in mind is that the common thread between all of them is that the person is tied to their employer and they generally can't work outside their sponsorship. That also means that if they are sponsored by an employer and they are an employee, if they are let go, they can lose that visa status immediately. And sometimes they only have 30 or 60 days to look for a new sponsor, or they have to leave the US. This has been a really big problem of late. You've probably seen in the news that Amazon is going to let 9,000 people go. Google let 10,000 people go. Approximately 10% of these positions that are being essentially phased out are foreign nationals that are being sponsored. We had 2 clients that were working for these big tech companies, and we had to scramble to see if we could find other options for them. And we have, luckily. Some people don't qualify, but a lot of these companies have also stopped their sponsorship of green card processes. So a lot of great foreign national workers are being left in the lurch. The periods of these visas vary depending on which ones. And some don't have technical limits, like TN visas for professionals from Mexico and from Canada. And then O1s, which are generally associated with artists, but they're also used for all other professions: scientists, mathematicians, business people. If the person is well recognized in their field, then they can be sponsored. And the beauty of the O is also you can have an individual sponsor and then have shorter term contracts. It allows you to work essentially as an independent contractor as long as your sponsor is signing off on the contract. So that gives people a great flexibility with the O, and there's no limit in terms of the renewals. What we generally try to do then is transition them to what's called an EB1, Extraordinary Ability Green Card, and we'll talk about that. The beauty of that is, and a lot of people don't realize that that exists. I've had clients that were on O1s for many years, and then I said, you should apply for an EB1, and they got self-sponsored green cards. So it's important as brokers and people that work with international folks to know all the different possibilities they have, not forgetting about their spouses who might have passports from other countries or might have advanced degrees, to be able to use them as a bridge to the green card, which is what most people want. And the great thing is that this is federal law, so it's not restricted by state. That being said, if you're advising your clients as sort of the person that is the gatekeeper, you want to have in your back pocket somebody who's well-versed in tax, cross-border tax, as well as potentially trust and estates attorneys that work cross-border, because that has to be part of their pre-immigration planning. The taxable part, depends not only on federal, but it depends on states, the states where they live and the states where they work. And so it's important to have those people also as part of your international team for advising your international clients. H-1Bs, we're right in the thick of it now. Why? Because H-1Bs they're going to announce in 9 days which registrations, which lottery entrants were chosen blindly. And last year we had about 300,000 that were entered into this blind lottery for 85,000 spots. So this is US employers hiring foreign nationals. The majority are on the F1 visa, or they're in this OPT period that I talked about where they're authorized to work. And this is a great visa for bridging the F1 students and changing their status to H-1B. The expectation is that eventually there will be a green card sponsorship. But because there's an annual cap, and it's talking about 1/3 at the most that are actually being selected, if there is a plan B, it's usually better than the H-1B. And so you have to evaluate country of origin, educational background, and sometimes what we do is take these students and we turn them into entrepreneurs if they're from countries that allow them to get visas based on investment, and we'll talk about that. The L1 is really a great visa, and you may have heard of it. It's a company visa. It's called the intra-company transfer visa, and it's contemplated for multinational companies. But that includes individuals from certain countries who cannot get an investment-based visa, and they set up a subsidiary of their foreign company. So E2 is a visa we're going to talk about in a second, and I've talked about it in the past. You have to be from a specific country or have a passport from that country to qualify. And so a lot of your clients may come from India, from China, from Brazil, countries that are not included on that list. If they have an existing foreign company, they can set up a subsidiary and then be transferred to run the US company. That foreign company must have existed for at least 1 year. And the person who is to be transferred must have worked for one of the foreign entities for at least one of the last 3 years. And they have to be on the payroll, which is really important. We have a client, it's called Joe and the Juice. You may have seen it in New York City. If you've been into the city, it's in about 10 other cities now. We've done something like 30 or 40 of these petitions over the years. That's how they bring their managers. And as long as their managers and executives are working for related entities, which in this case is any subsidiary of the Danish company, the parent company, they can qualify for this visa. So it's a great way to use, it's a great visa to use for your clients who are corporate, who work in a corporate world, because it also is a great bridge to the EB1 multinational manager or executive green card. I know that's a mouthful, but L1 is great because it is not country dependent. And so it's really important to keep that in mind. If it's a corporate backed visa and they have the capital to set up a subsidiary and a real plan to grow, then it's a perfect tool to use. A couple of very sort of high level things to keep in mind. There are two categories. There's L1A for managers and executives, and there's L1B, which is called specialized knowledge. That is more limited because you cannot just bridge directly to the green card, but you can do something called a labor certification. So that's for people who can show that their knowledge is unique and proprietary specifically to the employer. So we see this mostly with intellectual property, software, that nature, some things that are very technical. The L1A, the important thing to keep in mind here is that once they've renewed their visa, and this is up to 7 years for L1A and up to 5 years for L1B, they can then bridge to a green card. And that's when they have quote unquote been removed from day-to-day activities. What that means in practice is there need to be probably 7 or 8 employees on the US payroll, and there has to be a hierarchy, executive, managerial, and subordinate employees, to justify that that person is spending 100% of their time executing specifically managerial or executive duties. It's very technical, but that's the point at which we submit a case for a green card. These two visas, what they have in common, H-1B and L1, is that they have what's called dual intent. And of course, intent is subjective, but when it comes to immigration law, and I just did a presentation with a trust and estates lawyer, and there's a lot of cases that are analyzing the intent that's behind, and that's very important here. You have carte blanche if you have H-1B or L1 to then apply for a green card, and it won't affect your ability to transition or to renew that L1 or H-1B status, because you're not required like I talked about with other non-immigrant temporary visas, you're not required to show that your intention is to go home, because the inferred intent, what's assumed here, is that you will eventually apply for a green card. So L1 and H1 visas have special treatment, and it's a little bit easier to maneuver in terms of when to apply for a green card. And I'll explain more of that. Those are what are called dual intent visas. So let's go to the gray area. As many of you know, my favorite visa to work on, I've done 500 or 600 of these in 20 years, and I've represented people from probably about 45 countries or so, is that you can self-sponsor through a company that you set up in the US, but you have to have a passport from a country that has a treaty. Portugal just had their treaty essentially enacted, which means now Portuguese citizens are available or eligible to apply for E2s. And the way it works is you set up a US entity, you create a business plan, and you fund the US entity with sufficient funds to create a certain number of jobs. It's not required by law, there's no minimum, but in practice, you're looking at 2 the first year and then 1 each year for the next 4 years. And depending on something called reciprocity, the term of that visa length has a different maximum depending on what country you're from, but it's all about job creation. And what we're seeing is, or what we've always seen is, people from countries that don't have E2 access, like the BRICS countries that are on your screen, they then go the L1 route, or they go into the EB5 space, which when I started presenting for LIBOR was much more popular because it didn't take such a long time to process. And so E2 is a great option, and in many cases, it's the best option. The one downside of it is that depending on where you're from, the maximum length of time could be reduced. So I don't know if you guys heard or when this was happening, but there was a really strong friendship, they called it a bromance even, between Sarkozy and Trump at one point. They seemed to have a very good friendship. And then what happened was, through this reciprocity process, the US limited the French E2 from a max period of 5 years down to 25 months, which matched the amount of time that US workers could work in France on one visa. And that's when the bromance broke up. And so this is very interesting because it will affect your decision of which visa to choose. Some countries like Argentina, my home country, get 5. Some get 3 months, which, like Egypt, which makes it virtually useless. Some get 1 year, 2 years. The Netherlands is 3 years now. And so it's important to keep up to speed on what the actual max period is when you're assessing whether you should go for this visa or not. What makes E2s sometimes unattractive to people is that they don't have a specific bridge to a green card. And you have to sign what's called a notice of intent to depart. So the timing of when you extend your E2 status depends on when you've started a green card process, and that's usually being sponsored by a different company. And that process, as I'll explain in a minute, can take up to perhaps 3 years. So sometimes you want to start that green card process right after you've extended your E2. And so otherwise, they're going to say, well, you've now expressed what's called immigrant intent by submitting a green card case. We can no longer accept an E2 because your notice of intent to depart contradicts your intent to become a permanent resident. So when you're working with an immigration professional and you're balancing short-term and long-term plans, timing is essential. You have to make sure that you're planning it exactly to maximize those windows of time if people want to get that green card. I talked about immigrant intent. So that's when there's no going back. And this is declared officially when you submit a case for an immigrant visa, employment-based, family-based, or investment-based, which is EB5. And this can take 2 forms. This can take the form of a consular-based consular processed immigrant visa, in which case you're waiting outside the US, and this is very common in family-based cases, or what's called an adjustment of status. And with an adjustment of status, you're going from temporary status to permanent, but you must maintain that underlying status until you file. So you can't come in as a tourist and then overstay your 6 months of maximum stay and then be sponsored for a green card and then 3 years later apply. No, the only exception is if you marry a US citizen, what's called a bona fide marriage, a real marriage, then they will overlook your overstay. But I do not obviously encourage anyone to do that as your immigration plan. You have to otherwise maintain that underlying temporary status until you filed. What are these different alphabet soups in terms of employment-based immigrant visas? You may see this when you talk to your clients that may be here even on an F1 visa or a working visa that's temporary. The complexity of the path of each one of these depends on the category. So I talked previously about O1 extraordinary ability visas. They bridge to what's called an extraordinary ability EB1. And the beauty of that is that if you build the case well and the requirements are very transparent, then the person can self-sponsor, and they can also apply for adjustment of status if they're here. And you're looking at probably a year to a year and a half from going from the O1 to green card. The other EB1 category is what I mentioned, which is the bridge from L1, which is the multinational manager or executive. That does not require a labor certification, and neither does the EB2, which is called the national interest waiver. It's become very popular right now. The most important thing to keep in mind here is that the person has to have a lot of experience. An advanced degree is helpful, but the most important thing is to show that their employment in the US, and a lot of these are for entrepreneurs, so their creation of a business perhaps, will serve the national interest. And so you need to show a specific demand for that profession, like nurses, airplane pilots. There are some other ones that are really good right now because a lot of people retired during COVID and that left a gap. And there, or perhaps the situation in terms of the health standards in the US requires more nurses. You have to show that. You have to include studies that show that there's a need for that position and that the person qualifies. And that allows you to avoid what you see on your screen is called the PERM, which is a permanent labor certification process. Why is that more laborious, and pun intended, and does that take more time? Because you have to go through a recruiting phase and you have to show that the person that you want to sponsor is really the only candidate that meets the requirements and you were not able to find someone else. That process, called labor certification, goes through the Department of Labor, and right now can take between 18 and 24 months. Certified, then you can submit an immigrant visa petition and then an adjustment of status. So you're looking at potentially 3-year process. And for a lot of people, there is no other option but doing one of these PERM-based processes, and we do them all the time and they go well. But it's important to keep in mind that that takes time. The one that I've always talked about the most in these is EB5, and that's investment-based. You've all heard about it. They're extremely long processing times right now, something like 3 years, where you've invested the money, you can't touch it, then you have to wait 3 years to potentially get an approval. You might get a request for evidence, you might have to respond. Years and years waiting, and if you're from certain countries, depending on how many visas are being processed each month, you're looking at potential backlogs too of additional years, and that typically was India and China, like in terms of the countries that also had to add on to that long processing time, potentially more years of waiting. And that's a long time to have your money tied up, because then when you finally get your temporary green card, you're still required to remove conditions on that later and show that jobs are created. It's very, very cumbersome right now. Let's talk a little more about it. I already went into it, but you're looking at a way for foreign nationals to get green cards eventually for themselves and for their children under 21. So that's the age out. And you cannot remove the conditions on the green card that you get unless you show you've created 10 full-time jobs per investor. So that's always been the upside, is we've had cases where 4 or 5 family members and the principal investor get green cards. And as I've always talked about in past presentations, these are separate from real estate investment. And that's important for all of you to keep clear if you're new in this space, is that if you see something advertised as buy an apartment or a condo and get a green card through EB-5, it's probably not real. And your job as the gatekeeper is to make sure that these investment vehicles are vetted, because your clients can lose the 800,000 they put in, the 100,000 they put into administrative and legal fees, and then they can eventually lose their green cards as well if they're not investing in the right investment vehicle. Some of you have seen some of these projects like Hudson Yards and the Brooklyn Navy Yards. Specific regional centers are usually the way to go, but you want proof. And the way you ask for proof is you ask them for what's called number of approvals of I-526 cases. Those are the cases that are filed for EB-5. What's their track record? Do they have previous approvals? Do they have 100% approval rate? Can they prove that? Because if they can't, your clients are at risk, and you may lose your clients if you put them into the wrong investment vehicle. My advice is use a broker, somebody who analyzes projects specifically for EB-5, not an attorney, but someone that does analysis of projects for the purposes of EB-5 to make sure that they're vetted. The myth, as I mentioned, and I've heard this over and over, is that you can get it directly through purchasing a property. That's not correct. So make sure that you're being very careful about anyone that advertises that. If those jobs are not created, 10 full-time jobs through the investment made by that specific investor, then it's problematic, and it could cause you to lose your working relationship. And as many of you know, once you have entree into a specific community overseas, that will spread. The word of mouth will spread very quickly. You'll become the go-to broker for that community, unless you are somehow held responsible or blamed for a big mistake, which would be them not getting their full permanent green cards. So there's different kinds of investment. There's direct investment, there's passive. My general advice is to go for a project that allows you to come in at the minimum threshold, which as of now is $800,000. So you need to do a calculation and figure out how much money does your client have, right? Calculate $100,000 for administrative and legal processing fees. And then you have that leftover budget. So the example I give here is $2,800,000 for minimum investment in the project, $100,000 in administrative legal fees. That leaves you with a budget of $1.1 million to work with for your property sale. Make sure that you're separating those. If you want to sell it as a package and you vetted the project and they've okayed that, then you can sort of sell it that way with a total cost. But these are the numbers that you need to work with. And you have to be, like I said, I'm beating a dead horse, but you have to make sure that wherever they're investing has a track record that's established in order to protect them, their future, and their investment. We'll talk real quickly about family-based green cards. There are direct family members that are the ones that go through much quicker. And it's important, if you have clients that are green card holders, that they understand that the advantages are multiple if they also become US citizens. Not only will they be able to live abroad if they want and have no restrictions on their movement or how much time they spend in the US, but they can also sponsor more people as US citizens. They're very limited in terms of sponsoring people as permanent residents. That's really important. If it's recently married spouses, there's a conditional green card given for 2 years, and then you're required to remove conditions to get full permanent residence. And not all spouses are made alike. You have to look at the immigration history. So if you have a US citizen that marries a foreign national, You need to make sure the foreign national is actually eligible for a green card. Just because you marry a US citizen does not mean that you're necessarily eligible. They will overlook what I talked about earlier, which is called an overstay. If they've entered the US legally, they should be eligible, if it's a real marriage, to get a green card and eventually become citizens. But if they came in with what's called without inspection, EWI, then they need a waiver. It's called an extreme hardship waiver. It's very difficult to get. And if they've crossed the border twice without inspection, meaning illegally, they can never adjust. There's literally no exceptions for it. Even if they married a US citizen with $1 billion and a letter from the president, there's no way for them to get a green card. So it's important to understand the immigration history of the person that's being sponsored. We've had cases where the foreign national was not honest about their immigration past, and then they were denied at the last minute in the process. And so it's very important for them to be truthful about this. Residents, and you'll see this, people talk about this to different levels of complexities, including tax. When it comes to immigration, permanent residence requires that the person have the US as their primary residence. That means 183 days or more per year, they're expected to be in the United States. In order to not trigger any red flags or suspicion, they need to make sure that they're not leaving the US for more than 6 months at a time. If they leave for more than a year, and we saw this happen during COVID, where people couldn't leave or couldn't come back, or other things happened, or there's an emergency with their family or whatever it might be, they can resuscitate their LPR or legal permanent resident status through something called a re-entry permission that they process through the embassy. But if they've been out of the US for more than 2 years, their residency, their permanent residence, is considered abandoned. And they will have to start the process all over again. If that means that they got it through a spouse and then they got divorced, they're not going to be able to get that green card status back. If their green card expires, that doesn't mean they've lost their status, and it's important for people to understand that, but they are going to have to get a new card to be able to show that they are legal permanent residents and be able to travel. And so they really look at physical presence. And then in terms of tax treatment, this is where it's really important to keep in mind and to have in your wheelhouse a cross-border tax expert, people that work in trust and estates planning, because if they renounce their permanent residence and return their green cards, there is still something called an exit tax. And I can't take questions about that at the end because I'm not a tax expert, but I know some great international tax experts that can answer those questions. This all has to be part of the discussions that you have with your clients to provide them holistic services, not only in real estate, but to look after them and everything else. I know a lot of you know where the best schools are and daycare and logistical issues that you can help them with. They also need help in terms of their immigration planning and their tax planning and their estate planning. And this is all part of pre-planning when they're in the US, and if they're planning to leave, they might maintain their property, but they may want to principally reside somewhere else. And these are the things that come up. So a few updates. I mentioned this before. The EB-5 minimum is now $800,000. It's 1.05 million if they're not in a targeted employment area or it's a non-regional center investment. So the red flag should come up when they say to you, I want to invest in my brother's business or my friend's business, and I want to work with a developer. That's direct investment. And then you have to look at the specific area and see if the state is designated it as a targeted employment area. It's usually where there's a lower level of employment. And they need a designation in order to qualify, meaning they need a letter from the state saying this is a TEA area, specifically where it's located. I mentioned in this previous petitions an Indian client that bought a business on the wrong side of the highway, and they didn't qualify for that designation, which meant the investors had to bring in more money in order to take it. And most people want to use the lower threshold, which is 800,000. EB-5 is still very slow. If you see something about expedited processing, it's probably not real. The thing I talked about the most the last time were travel bans and national interest exceptions. Thank goodness those are off the table. There are not open borders, as people like to say, but there is full capacity now in terms of bringing in or allowing people to enter the US. But consular processing times are very slow right now. Some consular posts or embassies are not processing certain visas, and some are backlogged 1 to 2 years on tourist visas. So this is very important in planning. If your clients say, I have a year left in my visa, they need to get an appointment to then schedule getting their next visa, or they're going to be stuck where they, at a specific period of time, where they can't come back to the US. Unlike what we were hoping and all of us probably assuming, this administration is not any more kind or benevolent. Denial rates are still high. The adjudications are still quite arbitrary, and it feels like an extension of the Trump administration. And so what that means is that your client should not improvise. They should be ready and prepared for all facets and phases, which means immigration service, Customs and Border Protection, and their visa applications at the US embassies, which is Department of State. These are not easier times. As you've seen, there's a million different visa categories. The timing is important, the intent is important, and it's all about long-term and short-term planning at the same time before they enter, while they're in the US, and then if they plan to leave. So it's important to work with experts that know how to balance all these things and understand the process at each different immigration level. Last few thoughts. It's important to understand the basic concepts: temporary versus permanent, dual intent, immigrant intent. And this is, involving different letters of that alphabet soup, and you have to do it in the right order and at the right time. Nobody should be improvising. People love to rely, foreign nationals love to rely on public forums, on social media, what other people's experiences are. Every case is completely different. So each step and future steps should be part of a strategy, because otherwise some people jeopardize their short-term and maybe even their long-term futures. The immigration planning should be holistic, like I mentioned, including tax and trust and estates, working with experienced lawyers, CPAs who know how to manage cross-border planning. And then, stay attentive to the EB-5 minimum investment, because in the different presentations I've done for LIBOR in the last 3 years since COVID, it has changed and it has been paused and it has been reverted back, and it could change again. So it's important to keep on top of that, or to talk to somebody that is. And that's it for my presentation. Happy to take some questions.
Thank you so much, Steve. There were a few questions in the chat that I would be more than happy to ask on behalf.
Yes, absolutely, please.
So one question is, what about investor visas through franchises?
Okay, so first I'll just reiterate, there are two kinds of investor visas. There's E2 visas, which if you have a passport from specific countries, you can qualify. Those are short-term. They can be up to 5 years. They can be renewed without limits. And it depends on what country you're from, right? I said E2 is not a natural bridge to a green card. But that being said, and I talked about EB-5. EB-5, my recommendation is to work with regional centers that have an established track record and not doing your own business. With E2, you can do your own business. I think franchises are a wonderful solution for both. And there are companies, and I can recommend, if anyone wants to contact me directly, I can recommend a company that all they do is vet, analyze, and then they have portfolios for people, depending on what geographic region they want to live in, what kind of businesses they're interested in, maybe related to their previous experience, that have a great track record with approvals in both E2 and EB-5, and I've worked with them for about 8 years. So I think franchises are great. The difference, Evan and the person that asked, between a franchise and a business that's a foreign business or a brand new startup is it's a known commodity. It has an established track record, and you have the corporate backing of that company. They are doing the research and due diligence to find the geographic areas near where you want to live, where there's nobody that's competing with you. and there's a clear demand, and the supply is what's needed, and the supply is you as the investor. And so far, I would say almost all my clients have had great success when using that franchise. They're choosing the right one. And so they're luckily there's a business out there that will vet that for them and allow them to really dig deep. Because if you're doing it yourself, it could be very problematic. And buying an existing business, I don't think is an attractive an option, because immigration service or the embassies will always ask, well, why are they selling this business? How will it be grown? How will it create new jobs? A franchise means automatically new job creation. And that's the magic words for these. So I think it's a great way to go.
With well, I know Portugal, they're kind of steering away from the golden visa, but I'm wondering, you had mentioned that Portugal only recently got like enacted
Yes, right.
to that list. Did that coincide with what was that ever, were they ever like enacted at the same time that the golden visa was in, or did that happen after they kind of started steering away a little bit from the golden visa?
Yeah, no, that's a quite. I was interviewed about that because there's a direct overlap here, and it's very interesting. There is a contingency now that the U.S. has imposed, which is almost, I think you could wonder if it's actually overstepping in terms of jurisdictional pressure. But what they did was they took jurisdictions like Portugal, and Grenada was very popular for investing and getting citizenship because Grenada has a treaty and people were using it as a backdoor to get a passport and then apply for E2.
Mm-hmm.
So what the stipulation is that you have to have resided in Portugal continuously, or any of those countries that offer a golden visa, for 3 years before you can apply for E2 if you obtained it through that program. So that's a great question. So yes, you are eligible if you're from somewhere else and got a Portuguese passport through the golden visa. But if you're not residing there for 3 years, you're not eligible for the E2.
And then there would be that long line of everyone that's ahead of you first to get those.
Yeah,
Right?
and there is, because everybody who's naturally, native born Portuguese, or a lot of Brazilians with Portuguese passports, they're using that now. They're using that E2 through the Portuguese passport. Yeah.
Kay Song, who is in our audience, and she is actually our global chair this year. She mentioned that right now China has a 10-year wait for the EB5 visa. I thought that was an interesting fact.
Yeah, and it's just getting worse and worse. And I'll explain real quickly why. Back in 2007 was when the first time that this 10,000 visas per year cap was met. When they created EB5, they did not expect this huge rush. And when China's GDP shot up and properties became infinitely more, lucrative, and then we saw a lot more investment, there was this explosion of investors in the EB5 program. But as I mentioned before, not only do the investors get a visa, but all their family members. So all of a sudden, that cap, which is 7% per country, once you hit 10,000, it goes backwards, and then they apply that 7% cap. And so China has been really, unfortunately, great investors have been penalized because of where they're from. And now that happened with India. When I predicted 6 years ago that India was the next place for investment, that exploded. And now they have a backlog. China's the worst because it's just a numbers game now. And so that makes it infinitely less popular and attractive. I personally wouldn't want to wait 10 years to have a yes on my petition. That investment might have already been used. Those jobs might not be there anymore. It's extremely risky now.
I've always had a question, and maybe this is a little bit of an obvious answer, but when you do the EB5 visa and you get citizenship for your whole family, is it just your immediate family, or is there a cap on how many people can fall under that family?
It's much more complicated than that. Number one, once you finally get that petition approved, you get a 2-year temporary green card. Then you have to remove the conditions to show that 10 jobs were created as a direct result of your investment. You have to apply before your children are 21. You can only include children and a spouse. That's it. And then you have to get a permanent green card. Eventually, if you become a US citizen, then you can apply for your parents, let's say, or for a sibling. But we're talking, especially if it's a Chinese or an Indian national, 15 or 20 years down the road. So no, it's only direct family members, kids under 21 at the time you apply, and a spouse. That's it.
Sure. Aldo Ayala,
Hi,
asks,
Aldo. I saw
as
him
of
in
October,
Colombia. Yeah.
yeah, as of October 1st, US citizens need a visa to go to Brazil. What does that mean to the US and the Brazil relationship?
That's part of the reciprocity thing, although it's that at some point, there were countries that were on the visa waiver program list, the one I mentioned, and then they got removed. And what happened then is this reciprocity, which is really like political revenge. Other countries started requiring either a fee to come into their country or a visa. So I think this is just part of that reciprocity. I don't think there's anything else that's going to come back now on the US side. Brazil still does not have E2 status. And it's important for people to understand that the countries that I mentioned, the BRICS countries and others, 120 countries that don't, a lot of them don't sign an agreement. It's not that they just get extended this offer. They don't sign one because they don't want capital flight. They don't want hundreds of thousands of people leaving and taking their money with them to live in the US. And so that's probably why Brazil won't ever have an E2.
Yeah, that's an interesting concept because you're instantly thinking that maybe there's like bad blood, for lack of a better term, and that's the reason why they don't want to sign a treaty, but to keep the investment and keep the capital in their
Well,
country.
yeah, I'll just say real quickly, unfortunately, like I said, the Biden administration has been a huge disappointment. They carried on an initiative that started under Trump, which was to look at the visa lengths for US workers in every country and then limit the E2 maximum period to that period. That's why France went from 5 years to 25 months, and the Netherlands went from 5 years to 2 years, and they added the reciprocity fee. So now every Dutch citizen has to pay $202,228 per person to get their 3-year visa when it used to be free and for 5 years. And that dissuades people from applying for visas or from investing in the US. So it doesn't make any sense, but that's the reality that we're living in.
Sure. We have a couple more questions. I know that we're getting to the end of our hour.
I'm happy to stay on a few minutes if you guys are.
Your information is always so valuable. I think this might be almost the same question, even though it was asked by two separate people. So I'm going to ask it kind of together.
Okay.
Rajendra asks, is there a pathway to permanent residency through owning rental real estate?
So the answer is no. The only way that I've seen this happen is taking someone who has the capital to invest and rent, remodel, sell, more complex business model that necessitates the creation of jobs. So as long as you're building a team that might have a marketing, sales, maybe somebody that does construction management, et cetera, if you're building a team through something that's really a vehicle for you to make money, as long as the US benefits because there's job creation, you can channel that through an E2 or maybe an L1 visa if you have a foreign company, and eventually potentially get a green card through your own business. But you have to create jobs. And if you're not creating the jobs and you're the only one that's benefiting, it's what's considered marginal for the purposes of an immigration process, and you won't get it. So that's it. Do you really want to create jobs? Do you have a real business model? If it's just you, like I said, buying property, as all of you know, doesn't require a visa. It doesn't require you to ever step foot into the United States. Even you can own property in the US if you've never been here. If there's no benefit to the US, there's no incentive to give you a visa, and certainly not a green card.
Sure. In the Q&A, we had Ray Manzoni. He asked, he has someone who does work on his house, and
Okay.
he's unsure about their immigration status or how they're here. He knows that they're from Guatemala and that his wife is from Mexico. They have an ITIN number and pay taxes.
Right.
If they don't have citizenship, can they get a green card? How long could this process take, if possible? And so that they can buy a house and enjoy the American dream.
So there's immediately some red flags there. The people who have an ITIN, they have it because they can't get a social security number. You can come as a tourist to the US, you can overstay, and you can get an ITIN. Anybody can get one. And paying taxes, I love the immigrant mentality of, I'm going to do things right. And I'm eventually, maybe if there's an amnesty, which we always talk about, or some path to citizenship, that will be reflected well on them because they were paying taxes. Millions of people who are undocumented pay taxes. It's incredible. but there is no immigration benefit for that. I'm guessing that most likely they don't have any status at all. They might have overstayed. And it's a case by case. Millions of people want to sponsor these wonderful people, either as individuals or through their businesses. Problem is that most people are not eligible for any fix to their immigration status, especially in this case where the people are not married to a US citizen. If they were individually married to US citizens, they might have a path, but I'm guessing they probably don't. And I have to look at it case by case, so they're welcome to contact me. But my inkling would be that there's probably no solution for their situation right now.
Would that be almost like detrimental in their process if they are found out that they have been here over their stay and essentially are here illegally? Could that be detrimental in a process if they were to go through it?
I don't think so. I don't think so. It's case by case. I certainly think paying their taxes is never a negative thing. But really, I can't think of a solution that exists. A lot of people, the problem is that if they've overstayed their visas, or like I mentioned, they entered without inspection one time, they can't leave the US again. If you leave the US again, you will never be able to get back in. And they've made that decision. They made peace with that, and they hold out for potential amnesty. But I would have to review it just based on the specifics of each one of those individuals.
Yeah, I think just like more like a generalized information sense. And I think our last question that we'll wrap up with,
Okay.
can someone, and it actually flows perfectly with what we were just talking about, can someone apply for a change of status while in overstay if their spouse already has permanent status but is not a citizen?
So unfortunately, the rule of thumb for an extension or a change of status is once you've overstayed, there is no way to change your status. The only thing you could potentially do is what's called an adjustment of status, which I mentioned, which is going from temporary to permanent residence through your spouse. And that can be possible if your spouse is a US citizen. When they're just a legal permanent resident, that's a gray area. It depends on specific factors. So I would need to analyze that, but I would recommend that they explore that possibility, because recently legal permanent residents have been able to sponsor their spouses as long as they are in status when that application is submitted, which it sounds like in this case it isn't. So that means automatically my advice is have them apply for citizenship if they get it and the person entered legally and overstayed, they should be able to adjust, and I'm happy to assist with that.
Awesome. Well, I think that about wraps up our webinar for today. So thank you so much for being here. It is always such a pleasure to have you present to our memberships about all of the new updates and changes that are going on within immigration and visas. I mean, this webinar definitely said how many routes there are really that a real estate practitioner can use when trying to help out their clients. It's so much more of a complex topic than what I think other people are thinking. And a lot of people get hung up on the EB-5 visas. And your presentation title that you said, the alphabet soup of visas, we'll have to have you present on that one day, because that is, I love talking about the other visas that are out there and the other types of opportunities that are there for our, for everyone to get a little bit of their American dream going.
Thank you so much, Evan, and thanks to LIBOR as always for letting me collaborate.
Our pleasure. And if you're on the webinar, we hope that you join us for our last webinar of Global Success Month, which is next Wednesday from 12 to 1. We will be featuring Gonzalo Mejia, and he will be going over taking your global clients to the closing. Hope you all have a great rest of the day. We'll see you soon.
Thanks, everyone.